and put it online. Okay, wait, just okay. We are going to start this discussion of question five now. Okay, question five, you are asked to discuss in respect of criminal appeal, criminal appeal. So what is the duty of appellate court? That is to consider whether the conviction is safe or not. Okay, the question is quite broad, lah, I would say, for the question five, because Roman 2, they ask you about the interference that ought to be done by appellate court in terms of the court of first instance findings of fact. And then Roman 3, they ask you to comment on the power of appellate court to review or to re-evaluate all available evidence. So personally, I think there is some overlapping components that you might you might do in your exam question. Okay, so first and foremost, you must cite a few sections. This sort of question is not a broad and general question itself, but you have to cite certain provision of the Court of Judicature Act, because normally in Malaysia, not normally lah, in Malaysia, from a case could could come from subordinate court to high court, then Court of Appeal. That is one route. Second route, the Court of First Instance itself is High Court, then go to Court of Appeal, then subsequently ends at Federal Court, isn't it? So you have to cite three different sections. So that means to say all the superior courts in Malaysia, High Court, Court of Appeal, and Federal Court has appellate jurisdiction. And all those superior courts, they get their rights or their power from Court of Judicature Act 1964. This is very important. Okay, so Section 26 give the power of High Court um, to hear appeal from subordinate court, whereby Court of Appeal, the power is given for criminal jurisdiction, is given under Section 60 and also Section 92, Federal Court, Section 92 confer the power to Federal Court in term to, how to say, to hear the appeal. And there are some decision that could be made by those appellate court in regards to the appeal. Give me all first, Okay, they can confirm, reverse, or vary the order. Okay, that means to say they can either agree with the decision of the judge of court of first instance, or change it, or even reverse it from acquittal to conviction also can. From conviction to acquittal also can. Okay, so this is how. And subsequently, we have issues here. That is, wait. That is to say, wait, okay. Okay, we have um, constitutional issues here. Actually, the judge, normally how appeals occur is that, okay, one party is not satisfied, isn't it? Whether the DPP is not satisfied or the person get convicted is not happy with the decision. And you can only appeal based on errors made by the judge. You cannot simply appeal because you are not happy with the decision. You can appeal based on apa kekhilafan yang dilakukan oleh mahkamah di bawah. Okay, that means to say errors in terms of facts finding or application of law is wrong. Okay, two issues only. But somehow or other, the duty of the appellate court must make sure the conviction itself is absolutely safe. Because based on what principle? Number one is um, the presumption of innocence to be imposed on the accused until it is proven beyond reasonable doubt. That is one, presumption of innocence. And then the Blackstone ratio also is very important because this is an open-ended question. So you can actually elaborate whatever you want to discuss based on these two principles. If there is any form in terms of substantive justice is infringed or the procedural fairness is not observed in a particular trial, you can say that it has occasion in the miscarriage of justice. Then subsequently, the conviction itself is no longer safe. Okay, you get me? So this is the duty of the appellate court itself. The court above, the appellate court, normally what they are going to have is that they are going to have the paper, they are going to have uh the how to say, this is something like records rayuan, they are going to have bundles of documents whereby there is all the documentary evidence, the exhibits during the trial will be shown to them, as well as the alasan penghakiman and also the hujahan by both parties will be shown to the appellate judge, whereby they have to see it again and they have to read also the notes of proceeding in order to determine whether the trial has been done in an appropriate way or not. So this one, you can say like that. And how they do is, of course, they must independently reevaluate all the facts. And I think the second one is quite common because you may have learned the burden of proof and the section 101, 102, the Evidence Act. This is the basic thing, Often than not, sometimes the apprehension of legal burden of proof, whether it is on the accused or on the side of a DPP, sometimes is shifting, in terms of this, who has successfully discharged this sort of earnest of proof. Judge might make a mistake and misdirect themselves into believing that this is the way, which is wrong lah. Okay. The third is like what I've said, the procedural fairness is not observed. Like for example, the guilty plea has not been taken when the accused is understanding the language. We have seen it quite often because the time constraint issue. So the judge will really have no time to go through every single case. Sometimes the accused said they understand Bahasa Malaysia and just note their head, it will consider as a guilty plea. Okay. And judge will have the option to overturn the certain judgment made by his previous colleague lah. I mean the lower courts. Okay, so this is how the appellate court safeguard the issue whether the conviction is safe or not. Because Blackstone, the famous judge, once said, "Better let 10 who is guilty to escape rather than letting one innocent people to be caught and retained by the state." So more or less giving to the effect of this meaning. Uh, so at the end of the day, how you do this question is you must agree with this statement. You agree and say that it is the duty of appellate court to safeguard every single conviction must be safe before it can pass the sentence. Okay. Second question is quite interesting. I think a lot of people know already by now. The appellate court will be reluctant to interfere with the facts finding, okay, with the facts finding of the trial judge. Why is that so? Okay, why is that so? Like I have told you, the appellate court will only read the the record rayuan. They will not have time to listen from the witness. Okay, they won't have time to listen to the witness. So, from this paper itself, it's very hard to determine a few issues. Number one, whether the witness itself is very convincing, very confident during giving the testimony. The appellate judge is not sure. And you can't see his demeanor. For example, brushing the nose, okay? Keep on blinking when he's telling certain facts, okay? Looking at the audience to get some hints of certain answer. He will not have the chance to do so, you know. The appeal court will just read from the notes of proceeding, which is just words, isn't it? So some issues, the judge at the court of first instance will have the chance to appreciate it. So the appellate court will rather not to disturb those facts finding. Okay, so this is very important. This is the number one issue that you must highlight during the examination. Why the appellate court is slow or reluctant to interfere the facts finding. And second thing is the appellate court will only interfere with the judgment of the lower court when the judgment itself is plainly wrong. That is to say, the judgment itself is unreasonable, totally out lah. And how the judge reached that conclusion, it is not supported by any credible evidence, but he did not consider any doubts raised by the accused, for example. All that will be a plainly wrong thing. Only that time, the appellate court can step in, you know. Okay. And you must know that the statutory provision of Court of Judicature Act, which we have mentioned earlier, the section 60 and also 92, the federal court thing, they are not intended to have a full-scale trial to run over again. This is just to cure miscarriage of justice. Okay, they are not going to um, run the whole trial by calling all the witness. It is just a retrial or evaluation of evidence based on the paper. Okay, I've told you many times, it's just reading the paper itself. Okay, so you can give a few case law and finally you put down your conclusion. You agree with this statement, saying that an appellate court should be reluctant to interfere with the trial judge findings of fact. It's a well agreed statement. Okay, as simple as that. Okay, then subsequently we move to the third question. Power of appellate court to review or to re-evaluate all available evidence. Okay, so how they did it is that, okay, again, you have to cite the section law. Okay, this is not a question about the revision, you know, but rather how the judge evaluate the evidence. Okay, maybe you can give me a second. Let me show to you. Wait, okay. Take for example here. You see, This is the thing that the judge is going to look at. So this is an appeal, I think, up to the Mahkamah Rayuan lah, Court of Appeal. So you are just giving the judge, the appellate court judge, the Court of Appeal judge, regarding to all this, all this, okay, the notice Rayuan, perintah termeterai, alasan, as well as the nota keterangan, what happened at the court below, okay. The notice Rayuan, all that I will show to you. So this is keterangan, notice keterangan. Okay, notice keterangan is here. Where is it? It's not here. Let me show to you. Are you with me? By the way, you can see my record, Rayuan, isn't it? So this is how they evaluate, Okay, alasan penghakiman, then subsequently they have all this nota keterangan, means what happened during the court time, and what are the evidence available. They'll go through 100 pages, sometimes even 1,000 pages of paper, and then they will try to formulate how the judge at the court of below formulate their answer. Okay, then they will find out from this is nota keterangan. You see on so and so date, who is the hakim and who is the DPP, who is the peguam. Okay, and then what are the question and answer? What is the examination in chief? What is the cross examination and what is the re-examination? Okay, all this they will evaluate. So this is how the appellate process is being done. And then subsequently, they'll find out what is the errors committed by the judge below. Okay? Hmm. So we are back to the question. We are back to the question. Okay. Uh, Okay, so this is how they reevaluate the records. Number one, complete reevaluation of the records. And then subsequently, they have to calibrate what happens in the trial court, why the trial court judge thinks that the other party, that I mean the respondent is wrong. Okay, because usually it's like that. Those who appeal, they are not happy. So they will be called as appellant, isn't it? Then the respondent um, is the one that the lower court is agree with. Okay, so when they reevaluate all the evidence, for example, they will try to calibrate this. How the judge reached this sort of conclusion. And C is something that you must bear in mind because we have two tiers of this two tiers of appeal, isn't it? For example, this case is coming from session court, going to high court appeal, and then subsequently going to court of appeal. Let's say, for example, session court said that the accused is convicted, guilty lah, okay? And then high court also supported that the accused is guilty. So court of appeal, you don't give too high hope. Normally, they will give concurrent findings rule. Okay, why is that so? Because two judge here, you must remember to overturn your colleague's decision is something that you ought not to exercise easily. Okay, so unless the so-called the judgment is totally in a very wrong direction or the sentence given is manifestly illegal. I mean, for example, if the law allow 7 years of imprisonment, you go and give 8 years, that one is manifestly excessive, isn't it? Uh, Situation like that, the court of the superior will overturn. Otherwise, very slim chance. And this section 317 and section 61, 93 CJA, sometimes the court can admit fresh evidence. Okay, if you read your CJA carefully, it is quite special. In criminal appeal, they allow fresh evidence. Normally, in civil case, if you do not tender one material evidence at the trial stage, take for example, if the case start from session court, you miss out a very important document. Okay, you miss it out by negligence, obviously. You miss it out. When you do appeal in High Court, this document cannot be tendered unless the Lard and Marshall criteria apply. Okay, that means to say this evidence you couldn't get it during the trial stage like that. And this evidence must be a very credible and a very important one to overturn the current decision. Otherwise, cannot. But whereby criminal appeal, for the sake of justice, okay, to balance it, the judge sometimes may allow, okay, and this is codified, section 61, 93 CJA, section 317 CPC. And of course, you can use other case law like R against Park or Lard against Marshall, okay, to talk about this fresh evidence lah. Okay. And of course, the remedial flexibility, the judge can acquit, can substitute lesser offense, enhance the sentence, or even order a retrial. Okay, retrial means to go back to the court of first instance and to hear this matter all over again. Okay, so this is how, and okay, we go to question B, section 178 CPC. Okay, you look at section 178 now. 717 section 178 now. Okay, this is under chapter 20 of CPC, and it is trials before the High Court. All right. So High Court itself, normally it's not the first place, to commence every single how the case. Okay. Normally, the accused will be arrest first, isn't it? Then subsequently, the accused will be remand. And then subsequently, the charge will be read to him. Charge normally will be read in magistrate court. But take, for example, if the subordinate court, for example, or I put it clearer is that the magistrate court has no jurisdiction to trial this sort of case because the punishment is normally heavier, death penalty, imprisonment, for example, for high court transfer lah, normally death penalty lah. Okay, it will require the case to be transferred to high court, and when the accused is being brought to high court, the charge will be read to him all over again. So this is the whole procedure. Okay. So what are the instances to affect the so-called vertical transfer from subordinate court to go to high court? Uh, I think we have discussed several of the this year. I think transfer proceeding they put it a lot. I don't know why they keep repeating the same question. Okay. Section 177, that is the transfer from subordinate court, whereby it is lack of jurisdiction that can transfer. For example, particularly murder, kidnapping act, the FIPA, DDA, SOSMA case, they can transfer upwards. And section 177A, for those offenses exclusively triable by High Court, they can transmit. Okay, so this is provided they have the written consent by PP to prosecute. Okay, izin untuk mendakwa, the one that I've shown you earlier. The early birds will know lah. So this is a form of paper signed by the DPP, and this case itself will be transmitted from magistrate court to High Court. Of course, it is another date lah, another date. Okay. And in the event, for example, if let's say the accused withdraw the guilty plea, for example, he is charged under section 39B DDA, but subsequently he withdraw, and then the pathway uh, is affected lah, is affected. Okay, but normally that sentence, this one I just want to do a correction. The magistrate court will only read the charge, but they will not ask the accused to plead guilty. Okay, so this is how. And section 418A, PP certificate to transfer. Usually high profile case, they will exercise it. Like for example, the case of Datuk Sri Najib, by right, session court will have the full jurisdiction, sentencing or trial jurisdiction to hear this sort of corruption case. But because of its high profile complexity of the legal issue, etc., the PP will give a certificate under section 418A to require the case to be trial at the High Court. So this is one of the easiest way whereby PP need not to produce any reasoning. That means it is under its constitutional prerogative. Okay. And 417 is another transfer lah. Okay. And statute specific gateway. There are certain statute that require the case itself. For example, section 41A. Automatically it will be transferred. Even without using criminal procedure code, the act itself is so specific. If an accused is charged under drug trafficking, it will go under High Court. Okay. And some circumstances, for example, there is a joinder involved. I give you one example. If there is a core accused, okay, take for example, there are 4 persons here. They rob me, okay. They rob me, A, B, C, So all 3 together rob me, but subsequently I insulted C and C stabbed a knife into my abdomen and I die. So C will be charged for murder, isn't it? And then ABC will be charged together for gang robbery because of the the it happens in a single transaction. So all 3 of them will be charged in the High Court. So to facilitate the hearing like that. Okay. So this is the charge upgrade. Also, there's one instant. For example, initially the DPP just charged with culpable homicide under section 305 4, but subsequently upgrade or amend the charge into section 302. And then this will instantly transfer. Okay, transfer. And if there is any revision, take for example, if the High Court judge exercise its revisionary power, revisionary power is something like the supervisory power of High Court to overlook any miscarriage of justice that happens in the subordinate court. Take, for example, it feels that the session court or magistrate court cannot handle the case due to certain circumstances, okay, then probably it will have the trial in the high court itself. Okay, so this is how okay, if I were you, for question 5, I think it's not a favorite choice lah, because why I said so, maybe a little bit tips to share with you. If you are invited to discuss some general topics, and the marks is not much, sometimes you just couldn't appreciate how much you write, you tend to overtime yourself. You get me? Like you give a lengthy question answer, but subsequently all this you are not given a very luxurious mark lah. That is what I would say. Okay, I will choose question 7 uh, in comparison to question 5. This sort of breakdown is good for factual question. That means to say you are asked to comment certain uh, scenario and give opinions, because that one you wouldn't be too wrong if let's say the you got this particular question wrong. Okay, but whereby like you want to give essay question like that, it is not wise to choose the question that carry very little mark. Okay, this is what I try to let you know. And okay, so this question 6, Hero was charged with statutory rape. So that means to say rape the girl under 16 years old. So this is statutory rape, regardless whether the girl has given any consent, it is still considered uh, an offense, a rape under this section 376 subrule 2 subrule D, provided the accused have sexual intercourse with that underage girl. Okay, so this is statutory rape. And then the charge was read to him at the session court Kangkar Police before Tuan Adil, the judge, and he refused to plead guilty. So what is your advice to the court in terms of the procedure, how to take a plea from the accused person? Okay, so number one, before you can even comment about how to take a plea, you must ensure that the accused is fit to plead guilty. That is to say that he's not unsound of mind, he's not crazy, and he understands what has been conveyed to him. Okay, so you must rely on section 342 CPC and one good case here, Misbah Saad. Okay, so when the accused has been read with the charge, okay, the charge itself will be read out by the interpreter. So Rose will be the one that read the charge to the accused, Mr. Hero, read aloud and explain in the words that the accused understood. So normally it's in Malay lah, by interpreter or otherwise. Okay, sometimes in a very busy setting, DPP also can read the charge. Okay, not necessarily the juru bahasa, okay. And subsequently, he will be asked under section 173 subrule B whether he wanted to plead guilty or not. The whole process is like that. The charge is read, and then the juru bahasa involved, Rose, will ask whether the accused mengaku bersalah atau tidak. Okay? If let's say the accused plead guilty, the court must ensure that there is a voluntariness from the accused. He's not under any form of threat. He understands the nature and consequence of guilty plea. Okay? And he must plead guilty without any qualification, without any reservation, and that guilty plea itself must not be ambiguous. That means to say the plea is very clear cut. Saya mengaku bersalah. Okay, not like saya mengaku bersalah kerana saya mau mendapat hukuman yang lebih ringan. Not like that. This is subject to the condition the judge must provide him with lesser sentence. Okay, saya mengaku bersalah sekiranya saya boleh dilepaskan pada hari ini. Cuma denda sahaja. In term of fine lah. Cannot. Okay. So UNCP, the unequivocal, unqualified, all that you must highlight. And subsequently, after the guilty plea, the judge will not record the guilty plea, but rather the statement of facts will be read out to him. Okay, what is statement of facts? Later, the question 7 will ask you to discuss. They'll read out this statement of fact. Then the court will ask the accused to confirm his guilty plea. Masih mengaku bersalah atau tidak? If let's say the accused still mengaku bersalah, then the judge will record the guilty plea and give sentence. It could be on the same day, otherwise it could be adjourned to a new date. Okay, so this is how and advise the court what is the trial procedure to be followed if hero refused to plead the charge. Okay, take for example, this is a very stubborn accused. He stand mute or expressly in this scenario, I think it's more in favor of expressly refuse to plead. So section 173C, I hope you are with me. Section 173C. If you take a look, what does it say? If the accused refuses to plead or does not plead or claims to be trial, the court shall proceed to take all such evidence as may be produced in support to the prosecution. Okay? So what does it mean? If the accused do not plead guilty, okay, that means this whole case will go for trial, Okay? And in criminal trial, DPP, the prosecution will need to start their case. So usually in this sort of circumstances, the accused refuse to plead guilty. What they'll do is the court will set a new date. Okay, for what? For case management first. So during the case management, section 51A CPC, the exchange of documents will happen. And in between, if you like, you can have a pre-trial conference or the conference with the judge also to enter into plea bargaining, all that. It could happen. And subsequently, if all this have done, there will be the trial date, tarik perbicaraan. So during the tarik perbicaraan, the prosecution will need to summon his first witness and start to tender all the evidence as exhibit or the identification, the ID lah, during the court. Okay, so this is what it meant by it. Then, okay, so this is under section 173, subrule D to F. All these weaknesses of the prosecution side, for example, the IO, the investigating officer, the juru gambar, photographer, and also raiding officer. Sometimes they'll ask the recording officer, the one that rakaman percakapan, or saksi awam to come to court. So all of them will be having EIC, CE, RE, and then all the evidence will be tendered through all these relevant witnesses, okay, and be marked by the court, okay, marked by the court. So at the end of prosecution case, when the prosecution has finished all his witness, that means to say dia sudah tutup dia punya prosecution case, tutup lah, okay. Then the judge will need to decide whether a prima facie case has been made out based on the evaluation of the evidence available to him. Okay, so this is under section 173 sub F of CPC. Okay, if prima facie case is made out, okay, hero will be invited to enter the defense. And usually, but not usually, all the time, the accused will be the first witness. Okay? After that, after listening to the defense case, okay, for example, we call the accused, a few supporting witness, okay. After that, the judge will made out his case. We will do a submission at the end of the trial, and Tuan Adil will need to deliver his verdict. That means to say whether he wanted to convict or acquit Hero. Okay, with this relevant statutory rape lah under penal code. Okay, so this is how it goes, and throughout the process, you must remember there is case management, so this is, I think, the complete answer for question A. Okay, question B, question B is about, actually this question is two in one. Okay, first they ask you to comment the transfer of proceeding, and second, they ask you whether the joint trial is a viable option or not, whether the application by DPP to transfer the case or having a joint trial at the same magistrate court at Georgetown will be granted or not. Okay, the facts of the case is like this. This Mas Naka had a case already in Butterworth Magistrate Court, and he was charged under Section 379A of Penal Code. That is stealing a motorbike. Okay, the motorbike number is PC007, and you must pay particular attention on the date, the date, and also the location. Okay, then earlier 4th January 2022, he got another charge of Section 411 Penal Code at Magistrate Court in Georgetown for the offense of dishonestly retaining stolen property. Okay, so this is also pertaining to a motorbike, but different car plate. Okay, as you can see, and also different date place. Okay, and what happened? because for the convenience, on 10th of September 2022, DPP Tuan Mas actually applied to transfer the case to magistrate in Georgetown so that both cases could be heard jointly. That means to say they want to gabungkan case, dua-dua case untuk didengar serentak di itu Mahkamah Magistrate Georgetown. Okay, so we are asked to comment whether Tuan Mas application will be granted by the court or not. Okay, again, this is a transfer proceeding. I think this year they really test you almost 50% of your question is about transfer. If you miss that particular topic out, you will lose a lot of marks or opportunity to score. Okay, so like we have discussed before, who will decide the place to have a trial ongoing? Normally is at the hand of DPP. I said many times, DPP has a lot of power in criminal case. In terms of decision where the place should be the trial place, the DPP almost have the absolute say. So in terms of transfer, by virtue of section 104, they can use 417, they can use 418A, whatever. DPP, I think, will get the transfer. Okay, they can move the case to Georgetown. That one is no issue because we have discussed in our previous lecture about it. But a successful transfer may not grant automatically a single joint trial. This one you have to pay attention. This is the additional point here whereby the jointers rules apply, in which by now you should have realized one charge, satu pertuduhan, one trial. Okay? Satu pertuduhan, satu perbicaraan yang berasingan. So this is the purpose laid down by section 163. Okay, I give you one example. If let's say I steal a phone, okay, on 28 July, and then today, I steal another new this iPad. Okay, this iPad. So this amount to two crimes, two charges. By right, I should be entitled to two separate trials. I need to go to court two times lah. Easy saying is two times lah. This is because the judge should not be having some prejudice that I am caught with so many charges. Because at the end of the day, judge is a human being. They will have bias. They will have some sort of perception that, oh, this one always do lah. So you gabung 10 charges in a joint trial, make him look bad. Anyhow, he will get convicted. It should not be done like that lah, because justice is the court must uphold justice, isn't it? So therefore, one distinct charge, one separate trial. So this is the general rule. So any departure or any going away from this rule is only allowed in some circumstances highlight below. Okay. Section 164. If you look at section 164, is the joinder up to 3 offenses of the same kind committed within 12 months. Okay, you see, you look at it, it sounds like this provision is fulfilled, because March 17 March 2022 is the first charge, isn't it? The second one is what? 28th of December 2021. So this is in the duration of 12 months, isn't it? Okay, and some more, it is about the theft of motorcycle. But in my opinion, I think this cannot fit in, because if you look at section 164 clearly, you see the final paragraph. Are you with me? Or you are sleeping? You look at section
Clear,
one,
clear.
you look at section 164, very important. Those charges associated with theft, if you look at the schedule behind, then you'll know this is associated with theft and also robbery. Those are deemed to be the offenses of the same kind. Okay, but theft for the motorcycle under section 379A and also section 411, the apa simpan barang bongkar, is actually different penal proviso. So section 164, is not available to be used here. Okay, this is understandable. Okay, and section 165, in order for you to use section 165, how you want to use it is the thing must occur at the same transaction. Okay, take for example, okay, I am the accused. I I enter into a house, and then subsequently I rob a girl. I rob a girl, and then subsequently, because she's young and pretty, I rape her. So you can see this transaction has the proximity of time. That means to say the time is not broken. It's not after one day I rape her. It will broke. Okay. The time is not broke. The place itself is still inside the premise, the house, and also the design itself lebih kurang sama. Because I robbed the girl and therefore suddenly I had the niat untuk melakukan jenayah rogo. So all this rape 376, okay, and then 379, it could be done in a joint trial. Okay, so that is to say PP versus Ji Hui Bing. Pertuduhan pertama mencuri barang. Pertuduhan kedua merogol. It could be heard in one single trial altogether. Okay, you get me? So this is how. But in our factual scenario, clearly we do not have those criteria satisfied. So section 165 also cannot be applied. And section 166, section 166 is what? Normally, if let's say the charge itself, there is some certain, you can use what we call alternative charge, pertuduhan pilihan. Okay, ini lebih berat. And subsequently, because you want to save the time of court, usually the DPP will read out satu pertuduhan pilihan. It will deem to be one main charge and one alternative charge. In the case whereby if the charge itself is a bit doubtful, we don't know where to place. Section 166 say that these uh, main charge and also alternative charge could be trial at the single same trial. Okay. This is how it goes. And section 170 only apply when there is more than one accused. So clearly, it has no room here lah. Okay, no room here. And subsequently, you conclude that even though magistrate, the forum could be transferred to Georgetown, but magistrate at the Georgetown must trial the two charges separately. Okay, separately. So the transfer proceeding will be granted, but the joint trial application will be refused. So this is your conclusion, Okay. And C is that you are asked to comment what is the purpose of charge in the criminal proceeding. Okay. I show you one more time, what is the charge sheet about, since we stopped there just now, isn't it? So this is the charge sheet. Okay. First, this charge itself will be read to the accused. You agree, Read to the accused. So the accused will get a notice. It serves two-way, to give a notice to the accused what are the particular crimes that he committed, when is it, where is it, and what kind of offense is it. Okay, because hukuman is there. Dakwaan section mana, so that the accused can prepare their defense. Okay, or another way is that the accused can plead guilty. Betul tak? Okay. At the same time, this charge itself, the charge sheet itself, will give information to the court, because court is very busy, isn't it? So this charge itself will give automatically the outline of the case to the trial judge. Automatically, when the judge read this, oh, inilah offense. And then subsequently, inilah kuasa saya. Saya boleh hukum up to tidak kurang daripada 5 tahun, tidak kurang daripada 10 rotan. Okay, so this is my jurisdiction. So the court also in reciprocal get the information what DPP want to do with this particular accused. So this is the primary purpose of the what we call the charge sheet. Okay, wait, let me share. Share back my um, okay. So I already told you, first is to give notice, and second, information to the court. Okay, Humayun Shah against R. Okay, so this is a little bit to do with constitutional fairness, Article 5, right to the fair trial. Okay, you must inform to the accused what is the grounds of his accusation. So, very important. So these are the uh, purpose of the charge. But at the same time, I think it is worthwhile for you to cite a few session. That is section 152 to 154 to perfect your answer. Because CPC, you cannot give general answer without giving the precise statutory provision. Okay, statutory provision is more important than case law. Very important, Okay. And we come to the final question before we go to some extra tips that I want to share with you. Okay. So this is a question that asks you to discuss about Pat Hurt case. Pat Hurt case. Pat Hurt case means because normally let's say, for example, the magistrate or the session court judge, or even the high court judge, lah. Okay. The prosecution already called two of the witness, for example, but he has remaining five. Suddenly, when we are waiting for the next trial date, this judge got transferred or retired or some other reason lah, quit from work. Okay. Now the case will be left to the new judge, isn't it? New judge. Then how do we ensure the new judge knows the demeanor, the credibility of the two prosecution witness that had already given their evidence in the court, okay, their testimony in the court? So there is something called de novo. De novo means to start new, okay, to start afresh. Okay. Actually, in this sort of scenario, usually civil case they will just take whatever left uh from the nota lah, the nota written by the magistrate. But criminal a little bit special. Okay, criminal, the accused may entitled to recall the so-called the previous witness that had already testified. That means the prosecution witness 1 and 2. But this is not an absolute rule itself. Okay, there are a few exceptions whereby the court can reject such application. Okay, but as a general principle, the successor magistrate will normally start afresh. Okay, to ensure, because if you read section 261, now is the opportunity lah. I think your final opportunity already to read this section. Okay, you see, if you read section 261B, okay, 261B, the High Court can actually set aside, if let's say this is a butthurt case, okay, and this is one of the grounds of appeal, and the High Court judge think because the magistrate have not heard the case all over again in a de novo manner, he has prejudiced the accused. Okay, so this is something the high court judge during the appeal can set aside. So normally in practice, the magistrate will entertain the accused request to recall and re-examine the witnesses all over again. Okay, because remember, the credibility and also the demeanor of the witness is very important. But like I said, this right is not absolute. Okay, if for example, such application is just a frivolous, vexatious, or dilatory application, that means to say the accused wanted to delay the proceeding. Cannot lah, isn't it? This is just the delay tactic. Okay, cannot. If the credibility or of the witness is not actually in issue, okay, cannot. And if the witness has already been gone, I mean passed away, or for example, this witness is an IO. He retired from the police force already. Okay, sudah pension. So how you want to call him? This is going to be causing a lot of hardship to the prosecution, isn't it? So you cannot also. And some more, lapse of time is also one issue. Okay, take for example, the incident happens in 2019, and then because delay here and there, adjournment, and the case is 2025. It's already 6 years. Okay, take for example, the prosecution witness one and two give their testimony 2022. By now, you have a new judge. You want to recall PW1, PW2 again. Their memory will be impaired, you know. Whatever they say will be recollection of 2019 incident. So sometimes it's not fair for the prosecution also. Okay. So this is one of the reason. And if the issue is an interlocutory one, for example, a war down in terms of confession or any oppression on the side of accused, and this has already been finally adjudicated, it cannot be called again. So recall witness cannot. Okay. But generally, the judge will allow. The magistrate, the new magistrate, new presiding judge will allow that. Okay. And question B, you are asked, this one you must do. This question, these two, I think you must do lah, and you will probably score for that. Statement of facts. Uh, have you heard of statement of facts before? Anyone heard of statement of facts before? Prosecution version of case. Okay, you can say so. Anyone else heard of statement of facts before? I just want to know whether it's covered inside the syllabus or not. Okay, the brief facts. All right. Okay, at least somebody know a little bit about that lah. Okay, I'm going to show you what is statement of facts. I um, it is not the brief facts lah. Actually, it is okay. Wait on, let me show my slide. So after the pertuduhan dibaca, if let's say for example, if the accused plead guilty, like I've told you, the the court itself must repeat, you know, apakah fakta case kena dibacakan. Okay, so this is one example of fakta case. Okay, take for example, pegawai penyiasat sekian-sekian inspektor, so bersangkut ataupun bersandarkan lah. This is durian tunggal report, this one and the date apa lebih kurang, and then what happened? Sampai di alamat pengadu didapati pintu grill dan pintu kayu hadapan rumah dalam keadaan tertutup dan berbangga solek. Lepas tu, what happened? And then the police conducted the raid, for example, and found something. Okay, this is the case whereby heroin shabu was found. Lepas ditangkap, apa berlaku? Saya telah pun bagi tahu hak-hak itu tertuduh mengikut Section 28A KPJ and membuat police report. Okay, hasil this jabatan kimia menunjukkan uh, this monoacetyl morphines. Okay, what is the thing? So this is the fakta case, you know. Okay, so what is the purpose of having this sort of fakta case? Okay, so normally it is relevant, okay, when the accused plead guilty. Because pleading guilty is just a formality. The charge itself, you may see, the charge itself is even shorter facts about what is the offense of the accused, right? and also the punishment, apakah hukuman yang akan dikenakan. But the brief facts cover more. How does it commit the fact the offense itself? So actually, this statement of facts transform a formal plea into a factual admission. Okay, so the accused will not say that, hey, actually my guilty plea is done in a very blur manner. I have no recollection of whatever ideas. But after the statement of fact read to him, he has no excuse. Dia sudah dengar semula dan mengaku terhadap fakta case yang dibentangkan. Okay, so this is how, and it helps to fence in the prosecution case lah. Okay, how the prosecution is going to rely on the factual evidence to close their gap, okay, and provide reliable footing for sentencings, and also provide the accused fair trial under Article 5, because disclosure lah, you disclose whatever that happens done by the accused to him formally. And also, this is very important for recording so that any appeal comes, the statement of facts is given, you cannot say that the guilty plea is not there. Okay? So this is roughly how it works lah. Statement of facts. All right.